for the minor kin who are caring for their minor kin children. For many of the relative caregivers served by Family Ties, this assistance has allowed them to provide for their kin in ways they had never imagined, including securing safer housing, paying tuition for private education, repairing transportation that allows their children to participate in sporting, educational, and enrichment activities outside of their neighborhood. It's also provided relative caregivers with the means to meet the more basic needs of their family, including having enough money in the house, keeping the utilities, including the heat, paid up to date, and avoiding eviction due to non-payment of rent. The pilot program has been described by many of my caregivers as a blessing. However, not all caregivers meet the eligibility requirement of the program, including the cornerstone of that eligibility, legal custody. Therefore, they must rely on public benefits, including TANF and food stamps, which are often minimally or insufficient to meet their needs. As such, life continues to be a struggle to meet the basic needs of the children in their care. Thank you very much.
Thank you, Ms. Palmer. Mr. Frayden.
Thank you, Chairman Wells and other members of the committee. I'm going to depart from my prepared remarks for a few reasons. One is, the primary one I have to admit, is that as a lawyer and law professor, it's virtually impossible for me to stick to a 3-minute time limit. I'm just not accustomed to that sort of restriction. The other, I think, is that the discussion today has fleshed out so many very important issues in such a substantive and meaningful way that I'd like to cherry pick and address a few issues that I think could require just a little bit of underscoring, frankly. Council Member Che described the tension in a very vivid and I think useful way in sort of setting up what I think is a very real tension between broadening a statute and allowing for a greater likelihood of harm to a child, narrowing it, and making sure that parents who shouldn't be dragged into court aren't dragged into court. And I thought it was very, very, very vivid. And I guess the way that I envision it is to think of the doors of the courthouse right now as being closed. They're closed and padlocked to caretakers of children. The question that is before us is how far to open it, how far to open those doors, and how to open them. I suppose I want to point out that the area of domestic violence is a perfect crucible for analyzing that tension. Although I think the example that my good and respected friend Eric Angel raised about the potential for a batterer to sue for custody of the children with whom he has lived but are not his own is deeply a concern. One of the real benefits of this act for domestic violence victims, I think, is that it creates an option for victims and survivors of domestic violence that they do not have right now. If a victim of domestic violence decides that because of the physical harm that has been done to her, because of the emotional harm that's been done, because as a result of the violence she's lost a job or lost housing, and as a result wants to make a responsible parenting decision to find somebody else to take care of the child, her only choice, as we sit here today, is the batterer. This law, or a law substantially similar to it, will allow her to essentially select the person of her choosing. That is an option that she does not have right now, which segues to the next example and one of your witnesses later in the program, which is that it may be that that the victim of domestic violence doesn't perceive herself that way, but Child and Family Services has what they believe to be substantial reason to believe that she is a victim of domestic violence and that the child is in danger. It is not at all hard to imagine that Child and Family Services would say to a mother, you need to leave the batterer, you need to make sure that the child is not exposed to violence, or else we need to take the child because the child is at risk. That can be a very responsible position and approach for a child welfare agency to take. But if the parent disagrees with Child and Family Services agency, right now, she does not have a choice. If and when I pray non-parent caregivers are given standing and the doors to the courthouse are unlocked for them, the mother confronted with a choice between staying with somebody perceived to be a batterer and allowing the child to go to foster care will have another option. So I think, I want to say I think that there are some real benefits to victims of domestic violence of this bill. I think in general it actually does not affect the domestic violence community as much as it does in a sort of specific targeted way. The other sort of concept I want to talk about is this concept of a fit parent. You may or may not be familiar with a situation that was the subject of a piece by Arthur Delaney in the City paper in December, a case involving a child named Dontavius Green who had lived with his great-grandmother, who subsequently became my client. Lived with his great-grandmother for 11 years in the District of Columbia. His mother was, I proved I can't stick to 3 minutes. What I want to point out is that when the mother was sued for custody, her response was to come from North Carolina where she lived, put the child into a car and take him forcibly back to North Carolina, away from his home, his caretaker, the woman, his great-grandmother he calls his mother. He's still there today because the doors of the courthouse are closed to his longtime caretaker. My concern about the so-called fit parent coming back into the picture after 9 years when she's good and ready to take care of a child is that although she may be a fit person, she may have a job, she may have discontinued substance abuse, she may not be a fit parent for this child. It may very well be that Dontavius Green's mother is a perfectly nice person and perhaps could be an adequate parent for another child. But this child, this flesh and blood human being, Dontavius, has lived with somebody else as his mother in another home and had another life. And so I don't want to sort of let that concept go without that comment.
Thank you very much, Mr. Braden. That's a very vivid example of why this would be necessary. And I also appreciate the work that you have done around helping families work through these issues of determining custody for their children when they've been confronted with chronic and life-threatening illnesses and such. So thank you for your work and for being with us today and for your testimony. Ms. Palmer, thank you for your work. I'm quite familiar with your work, and you do a terrific job on behalf of our city. And the Family Ties Project is a terrific resource that I'm not sure hardly any other cities have anymore. And you have provided two cities in America.
Us in Chicago.
Us in Chicago. So thank you very much, because you're right. The fastest growing population of HIV and AIDS are women, and they often are the caretakers for our children. And you are, part of what your project does is to try to keep the children out of the child welfare system, where, you have to go through a pretty debilitating process of proving the parent is unfit. And, you help keep children out of our child welfare system, and so you probably also have saved us quite a bit of money as well. That's, there's a lot of good public policy in what you do. And Ms. Washington, as I'd said earlier to the grandparents before you, it wants you to know that we recognize it takes a lot of guts for you to be here today. And it's because you clearly understand what's at stake. With you, you made a plan for your children with someone that you trusted and felt sure